collection, storage, and usage of biometric data. B. Whether the Aadhaar Act and rules provide such protection, including in respect of data minimization, purpose limitation, time period for data retention and data protection and security. Whether the Aadhaar Act violates right to privacy and is unconstitutional on this ground, in context of Sections 7 and 8 of the Aadhaar Act. Whether the Aadhaar Act defies the concept of limited government, good governance, and constitutional trust. Whether the Aadhaar Act could be passed as money bill within the meaning of Article 110 of the Indian Constitution. Whether Section 139AA of the Income Tax Act 1961 is violative of right to privacy and is therefore unconstitutional. Whether Rule 9A-17 of the Prevention of Money Laundering, Maintenance of Records Rules 2005 and the notifications issued thereafter which mandate linking of Aadhaar with bank accounts are unconstitutional. Whether circular dated March 23, 2017 issued by the Department of Telecommunications mandating linking of mobile number with Aadhaar is illegal and unconstitutional. Whether certain actions of the respondents are in contravention of the interim orders passed by the court, if so, the effect thereof. Arguments advanced petitioners. The petitioners' foundational arguments were that the strict implementation of the Aadhaar scheme would be a grave risk to the rights and liberties of the citizens of this country, which ought to be secured by the Constitution of India. It was also contended that Aadhaar would militate against the constitutional abiding values and its foundational morality. It contained the potential to enable an intrusive state to become a surveillance state on the basis of information that would be collected in respect of each individual by creation of a joint electronic mesh. It was humbly argued that right to privacy was an integral part of right to life and personal liberty, and any restriction imposed on it should be in accordance with procedure established by law. It must satisfy the requirements of Art 14 and 19 also. The law imposing such restrictions should be just, fair, and reasonable. As per the facts and circumstances of the case, the restrictions imposed by the government on the exercise of right to privacy of people were arbitrary and unreasonable, as there existed no reasonable classification, and there was no nexus between such classification and the objective of the act. Information sought from the people severely violated the bodily and mental integrity of the people, in addition to having no relation to the objective of the act. Also, classification based on religion was not only discriminatory but compelling the people to disclose their religion was in violation of Art 25 of the Constitution of India, 1950 further, making Aadhaar cards mandatory for the purposes of benefit and non-benefit schemes would deprive the people of their choice while putting them under constant surveillance of the state. This would amount to grave violation of right to life, as it would encroach upon the dignity of the individual, which is the basic element of the Constitution. Arguments made against Aadhaar. Shyam Divan was the first counsel to start the arguments on behalf of the petitioners. His arguments challenged the Aadhaar program, the Aadhaar Act 2016 and related entities. He argued, the Aadhaar architecture is capable of tracking, tagging, and profiling of individuals, and hence it is unconstitutional. The UID has the power to cancel the Aadhaar number anytime, with the citizen having almost no redressal mechanism that deprives him of services for which he or she would need an Aadhaar number. Arvind Date or 1. Linking of bank accounts with Aadhaar violates rights of a citizen, guaranteed under Article 14 and 21, as they cannot operate accounts without linking it with the unique ID2. Aadhaar will destroy decisional autonomy, right of choice, which has been recognized in the right to privacy judgment, violates the principle of proportionality and rule of law as not having an Aadhaar, destroys the existence of an individual. P. Chidambaram 1. Certain provisions of the Aadhaar Act have no relation to the nature of a money bill. There are strict criteria of what will qualify as a money bill, which bypasses the scrutiny of the Rajya Sabha, as well as takes away the power of the President to send the bill back to Parliament for reconsideration. Provisions of the Act which do not fulfill the criteria of a money bill cannot be severed once the bill has been passed. Hence, the entire law needs to be struck down. Respondents. The respondents rebutted that bare minimal information was obtained from the individual who enrolled for Aadhaar